This next clip explores working with a jury, dealing with litigants in person, and first of all, decision-making.
Well, decision-making is at the heart of what we do as judges. We make decisions every day on cases, whether that's to do with case management or final hearings, contested hearings. It's very important that we make decisions without delay, because some of those decisions can have a significant impact and long-term impact on the individuals involved in the proceedings. It's very important when we make our decision that we consider all the information available to the court and take the time to explain our decision, our reasons, for those involved in the proceedings to understand.
Managing a jury is a really important part of the role of a Crown Court judge. And for me, sitting as I do part-time, fee paid as a recorder, it's my favourite part of what I do in the Crown Court. You have in front of you 12 people who probably have no legal experience, and they're probably feeling a little bit intimidated in the environment of the Crown Court. And so your job as the judge will be to put them at ease, to make them feel confident that as the judge you will give them all the legal information they need to make the right decision, and also to make sure that as a group they're functioning well together, that the dynamic works, and that enables them to come back with the right decision.
One of the difficult aspects can be having to make a decision under pressure of time, perhaps not having all the information available to you. In situations like that, it's very important then to establish what the real issues are that need to be resolved for you to make your decision. To arrive at that decision, having considered all the information, and then to be able to explain it to parties involved in the proceedings who may or may not agree with your decision. It's helpful sometimes to take the time out to gather your thoughts, put some thoughts in bullet point form, in writing, so that there is a structure to your decision making process.
Most people who come to social security tribunals are unrepresented, and so most of the appellants I deal with are litigants in person, and I have to say that's one of the parts of the job that I enjoy the most. In order to be a judge, you need to be interested in people, because you have, for the time of their hearing, got to find out quite a lot about them. People come to hearings in various states of anxiety, and especially if they don't have a lawyer to support and represent them, they will get very tongue-tied or just be unable to speak when the hearing starts. So I find often within minutes of them coming into the room, I will try to engage them in some sort of conversation that has the effect of settling them down, so that I can then really get on with the substance of the hearing and ask them slightly more searching questions.
A recorder has to give legal directions in every trial so that the jury understand the law which they are applying. That can be difficult and daunting, particularly if it's a case where the law is complex. We are trained to do that in the recorder induction course, which includes a mock trial where you actually practice in front of your peers giving those sorts of directions to juries. And as well as that, we have access to the Crown Court Compendium, which is a manual of sorts, which helps us by setting out in detail the sort of factors we should be considering when giving legal directions to the jury.
Depending on the case and the facts to be determined, an oral decision may be given after the evidence, or it may be that if it's a complex matter, a decision needs to be provided in writing. Irrespective, it's important that the decision is made in a timely manner. Parties understand the rationale for your decision, so using language that's easy for individuals to understand and follow is essential if they are to understand how you have come to your decision.
One thing I need to be aware of is language, the language that people use, because people use sort of colloquial expressions. So I find that I have to constantly check back that I've understood what they have said correctly. And that will mean I will say to them, I'm sorry, can you explain to me what you meant there? I'm making a note of the evidence, so I have to ensure that I have understood what I'm writing down, and there's a lot of checking back with the person who's telling me what they're telling me. All of that is balanced within the need to complete the hearing in the time allowed, but I tend to favour or I lean towards giving people an opportunity to give me the evidence that they wanted to give. If that means I have to take more time to allow them to speak, then I'll tend to do that.
The type of decision being made will vary from jurisdiction to jurisdiction, but each jurisdiction will provide guidance and support.
One of the real challenges when you start off working with a jury as a new recorder, I think, is to get the tone right, because you're not there to lecture to them. And I think over the months and 6 years now that I've been working as a recorder, I hope, developed a tone where the jury feel that we're working together as a team, so that their job is very much to listen to the evidence and assess the evidence, and my job is to make sure that the trial runs in a fair way and that I give them the right legal directions at the end. And when you get that sense of working as a team with a jury, it's a fantastic and really rewarding part of the job.